Hello and welcome. We're just going to wait a few minutes for a few late stragglers to join, and then we'll start shortly. There's a few more signing in, so we'll just get a couple of more minutes and kick off from there. Okay, I think we're all signed up. Well, hello and welcome. I'm going to turn my screen off now, just so we've got more bandwidth for my voice. But it's good to have you all. Thank you for joining the webinar. Please feel free to type in any questions you have during this session into the questions box, which is part of the webinar panel that we've got. I'll be happy to answer them at the end of during the questions and answer session. Right, just a brief note really about who we are. Well, Risk Crew are an elite group of information security governance professionals. We look after risk compliance and testing. We provide a 100% satisfaction guarantee on the work that we undertake. We're that confident in the skill set of the professionals that we've got working for us. And just some notes about me. I'm Andy Whitaker. I'm the Data Protection Officer for Risk Crew. Information security governance, risk and compliance professional. I've over 15 years of assisting clients with the implementation of data protection and information security management systems. I'm the acting DPO for several clients. I'm the lead ISO 27001 implementer for the company. I'm also a ISO 27001 internal auditor for a number of our clients. So I keep busy, but my main focus for some time now has been on data protection and GDPR. The topics we're going to be covering today. What is data protection by design and how do you ensure it? Now, how do you verify and maintain that you've implemented the principles? I'm going to give some examples of some key performance indicators which are very good for verifying that you've implemented principles. And then, as I mentioned, we're going to be having a questions and answer session at the end of it. And if you do have any questions, please type them into the box on the webinar panel, just so we can attend to them at the end. So what is data protection by design and default? Article 25 of the GDPR legislation, paragraph 1, has two principles. Now, the first principle places two key obligations on data controllers when designing products and services. The first one is to implement appropriate technical and organizational measures that are designed to implement the data protection principles. So it's basically putting the onus on the organization to implement the requirements, the measures needed to meet the requirements of GDPR. The second one is to integrate necessary safeguards into the processing in order to meet the requirements of the GDPR and protect the right of data subjects. Let's look at this first principle from Article 25. This requires that the controller shall, and this is the wording from the Act, so it's quite verbose, both at the time of the determination of the means for processing and at the time of the processing itself, implement appropriate technical and organizational measures which are designed to implement data protection principles in an effective manner and to integrate the necessary safeguards into the processing. So it's quite verbose, but it's fairly clear in its intent. It wants us to implement the necessary controls to protect the data and to meet the requirements of GDPR, which is essentially to minimize the data, which is the bare minimum that's required for the processing for the business requirement. Now, in terms of measures that could be taken, there are two examples given in the legislation: pseudonymization and minimization. Now, they're a good start, but they don't cover everything. Now, with this webinar, I will try and describe what data protection by design and default means to help ensure that you can understand it and comply with the requirement. Now let's look at the second principle from Article 25. The controller shall implement appropriate technical and organizational measures for ensuring that by default, only personal data which are necessary for each specific purpose of the processing are processed. Now, it's important to note that Article 25 mentions both technical and organizational measures. Data protection by design and by default is more than just an IT security problem and solution. It must encompass the people involved in the processing of the data. So what does this mean? Only the data necessary for each specific purpose is processed. That obligation applies to the amount of personal data collected, the extent of the processing of that data, the period of the storage, its retention period, and the accessibility of the data. It also mentions that in particular, such measures shall ensure that by default, personal data are not made accessible without the individuals, and by individual it means the data subjects, the individual's intervention to an indefinite number of natural persons. Basically, you cannot share that data with whoever you may want to without the explicit agreement of the data subject. All of these things involve decisions made by the people who collect and process the data. So it's very much a people sort of topic, is this, as much as it is about technology. Just before we go further into the presentation, we've got a fun fact here. And it's not a quiz, but well, we think we'll start a poll on this one. Was data protection by design and by default first introduced in the GDPR legislation? I'm just going to leave a few seconds for people to respond to the poll, and we'll see how that goes. Presumably you've all had a chance now to indicate. Well, of course, the answer is no. This concept was first introduced under the Data Protection Act 1998 as privacy by design, and it's essentially the same concept. Now, if you think about it, this concept has been around for at least 22 years. It's not new and it's not novel, but people still act surprised when they see it in the GDPR legislation. Now let's get back on topic. With personally identifiable information, less is always more. And what I mean by that is less personal data is generally more compliance with the GDPR requirements. Now, how do you get that? Well, first of all, you've got to understand the need, the business purpose for the processing. What is the business requirement? What is it you're trying to achieve? You have to limit the amount of data and the type of data you collect so that you can achieve that business process with the minimum amount of data required. Controlling access to the data includes all the usual user accounts and file permissions, but it also includes keeping the bad guys out. You have to ask yourself, is the network and the system secure? Who are you going to be sharing the data with, and why are you sharing the data? You also need to agree a data retention policy for the data. It is basically limiting the data, the type of data, and the processing to what is the minimum necessary to meet the business requirement. You should develop a policy on data protection by design and by default, encompassing these ideals. Define the policy, know what, so it's a way of distributing to the company what you want them to do. But that's not all you should be doing. The data processing impact assessment is a vital tool in this. It should be the first step in any new sort of undertaking. It's essentially a risk management process, but with a very narrow focus. Anybody aware or involved in ISO 27001 will recognize it, but as I said, it's very narrow in its focus, looking at the risks to data. Now, if done correctly, it will provide a structured and repeatable approach to evaluating the risks to the proposed processing. It allows you to take a holistic view of the processing and of the processing environment. Now, by environment, what I mean there is it's both the technical solution and the people that are going to be involved in the processing and using that technology. For example, are the people suitably trained and under an applicable contract? Is this a risk to the processing? You need to weigh that up. Where is the processing going to take place? Is that a risk? Or is the building secure? Has the network and the systems been security tested? Is encryption going to be used? Should it be used? These are all possible risks, and if applicable, measures may be required to reduce or mitigate them. And not forgetting the examples from the legislation, pseudo-anonymization and minimization. Is the scope to use these within the project, or should we be using similar methods? Now, does the proposed processing comply with your policy on data protection by design and by default? One of the things you should always do with a DPIA is conduct it at the earliest opportunity. And also, you should repeat it as often as required. To have a successful data processing impact assessment, there is a number of things that you should be aware of which will add value to this. While the previous slide depicted all the steps involved in a DPIA, there are a number of things that you really should consider. I think they're essential to making informed decisions during that DPIA. You need to understand the processing environment. Don't accept answers like, it's in the cloud. You need to know which cloud, whose cloud, why are we using cloud? You need to identify any special category data, data relating to children that are 13 years and under, or data related to criminal convictions. These need special safeguards. You need to be aware of it. identify any third parties involved in the life cycle of the data. And that's from the data collection through all of its processing to the eventual destruction of that data according to the data retention policy. Obtain any relevant security testing reports relevant to the environment. If they don't exist, push back to get testing scheduled. Map out the data lifecycle from collection to destruction, so you can see what's happening to it at every stage. Use scenario questions and answers to help gauge the likely impact of a data breach at various points. As I hope the graphic shows, DPIAs are not one-off exercises. A project may have multiple DPIAs conducted as the project progresses. Projects will naturally change due to events, unforeseen circumstances, different technologies being used instead of what was envisaged. All of these may have a bearing on the risks. They will require an additional DPIA to assess the risks associated with the changes. Now, legacy systems should also have DPIAs to identify any. Accountability is one of the main pillars of the GDPR legislation. Conducting DPIAs demonstrates the organisation is taking this seriously. Template DPIA forms are available from the ICO website. These should be modified to suit your organisation. Download the template from the ICO website and then modify it to suit your working practices and how the company operates. So I've just been flagged up with having some audio problems. I do apologise there. All of the information we're giving out here will be present in the slide deck. So all I can really do is carry on regardless. Now, how do you verify that your company or your organisation has implemented the design, protection by design and by default? Data processing impact assessments are a vital way of doing it. They generate their own sort of audit trail of things being considered, decisions made, risks, how the risks are going to be identified, and they have sign-off both by the DPIA and the project people involved. That gives you a very good audit trail. In documentary evidence, you are conducting privacy by design and by default. Contracts. Is there a contract or a documented business requirement to provide the justification for the processing? There must be some legal valid reason for the processing you're undertaking. Have the records of processing been updated? Now, the records of processing are required under Article 30 of the GDPR legislation. Is there a data retention schedule in place to cover the data that's being processed? Is there a data retention policy? Are there security assessments for the networks and systems involved in the processing? Security assessments generally produce reports. The reports are all documentary evidence that you're doing your utmost to ensure things are secure. Are training records available for the staff involved in the processing? And what we're talking about training is cyber security training, data protection training. These reports show that you're investing in your staff so that they know their obligations under GDPR. How do you maintain it? Well, DPIAs again. KPIs may and should occur at several stages during the project. As I've mentioned, projects change, and the data protection officer needs to be aware of the impact of those changes. The data protection officer needs to be aware of new developments. It's far easier to introduce the correct controls at the beginning of a project than to retrofit them afterwards. Periodic security testing of the network and computer systems involved in processing ensures security is maintained. Similarly, periodic data protection training for the staff helps to maintain their awareness of the data protection requirements. And lastly, a periodic review, almost an audit if you will, of the records of processing will be very helpful to ensure that the register is an accurate reflection of what your organization is currently doing with the data it holds. Here we've got another one of these fun facts. Now, has the overall levels of cybercrime increased because of the COVID-19 pandemic? I'm not sure we're having a poll on this one, so just a few moments to consider. Oh, we are having a poll. There we go. So has the overall levels of cybercrime increased because of the COVID-19 pandemic? It's a simple yes or no. Just give you 5 seconds to make your choice. Oh, the answers are in, and the answer is no. There hasn't really been an increase. Cybercrime levels have remained more or less the same, although from the data seen today, while it's not increased, what we are seeing is that there are more phishing attempts, there are more methods to try and use COVID-19 as a disguise for what the real intent is. So there's COVID-19 related themes by malicious cyber actors. Certainly has increased because it gives them an opportunity, but the overall level of cybercrime is about the same. Now here we are to a difficult one, key performance indicators. Now it's worth considering what the key performance indicator is intended to show. What we are trying to demonstrate is that privacy is factored into all the decisions on new processing or changes impacting existing processing. So privacy is the forefront of how we approach new things or changes to existing. Now, the default state must enable or maintain the privacy of the data subjects. The next slide shows 2 recitals from the GDPR legislation, which will give you some help of indication of what people are looking for. Now, recitals are provided as part of the legislation text to give guidance to specific areas or specific points. They don't form part of the legislation, but they are good to give guidance. Now, recital 78 says to be able to demonstrate compliance with this regulation, it should adopt internal policies, and we're talking about data protection policies, and implement measures which in particular implement the principles of data protection by design and data protection by default. Now, Recital 108 is all about transfers of data outside of the European Union. And so in the absence of an adequacy decision, and this is a adequacy decision, is where the European Union has deemed a third party, a third country, have similar protection mechanisms adequate for GDPR. So in the absence of an adequacy decision, the controller or processor should take measures to compensate for the lack of data protection in this third country. And they should do that by way of appropriate safeguards for the data subjects. And these safeguards should relate in particular to compliance with the general principles relating to personal data processing, the principles of data protection by design and by default. Now, they're a good way of demonstrating. If you have those, they're a good way of demonstrating that data protection by design and data protection by default have been encompassed by the organization. Now, here we have some example KPIs, key performance indicators. The first point is important, as it is in the second paragraph of Article 25. Data subjects can intervene in the processing. Now, what that means is, can you handle a subject access request to put a restriction on processing? It could well be to limit access if you intended to share that information with a whole host of other third parties. Maybe the data subject objects to that and wants to put a restriction on it. Can your organization cope with that type of request? Do you have any mechanism for monitoring and enforcing data retention schedules? There's not much point of having a data retention schedule if you don't implement it and enforce it. The deployment of malware detection systems support the default state principle by ensuring the processing environment is free of malicious code that could facilitate a data breach. The default state must enable or maintain the privacy of the data subjects. And here's one where it's a fairly typical example where I'm trying to get through what the default state means. Consider one of the staff of the data processors creating a folder on the data processing system. What they're doing is creating a folder to put some data in. Is the default to provide read access to everybody in that organization? Or is the default to limit it just to the small group of people who are authorized to see that data, to interact with that data? That's what it means by default, privacy by default. Lastly, the training records of the staff undergoing DPA and or cybersecurity training can also be used. Of course, 100% attendance is the ideal. Now, there are a few things to bear in mind with this. You need to be aware of potential projects. These could be new projects or changes to existing ones. Will it incorporate privacy by design and by default principles? Will it follow your policy? Always ask if this is the absolute minimum data required to meet the business objective. We've moved from a world prior to GDPR where it was common practice to gather and process as much data as possible. With GDPR, things have changed. We're now looking for a more minimalist environment. Updating the records of processing activities, it's a laborious activity, but it's a key component of documenting what the organization is doing with the data that it has. And it is, of course, a requirement of GDPR. Now, you must remember that the security of the personally identifiable information is paramount. Data breaches are to be avoided both for the potential harm to the data subjects and for the possible financial penalties for the organization. And it's one of the reasons why following the principle of privacy by design and by default minimizes your exposure to those risks. Now, I appreciate I've gone through a fairly quick pace on that one, but now we're coming to the questions and answer session. So I'll be interested in questions and answers. well, certainly what questions we've got, and I shall endeavour to answer any questions we've received. Okay, one of the questions we've got here is, when is the privacy by design principle most likely to fail? And the option, a new data processing activity in an established data processing environment, or building a new processing environment for the new process? That's a very good question. Yep, I would, in my experience, it's most likely to fail in a new data processing activity in an established data processing environment. And that's because the data processing environment may well reflect the processing it was originally set up to do. The new processing may involve different types of data, have different requirements. It may have a different lawful basis for the processing, and the environment may not be able to deal with that. But because it's an existing one, it generally gets less attention paid to it. Oh, here we go. What do I think the most common reason of misuse are? Lack of awareness, change of the legal basis, collecting too much data, or keeping data when it is no longer required. The most common misuse I've seen is keeping data far longer than it's needed. Absolutely. And it's down to the mindset that we're having to adopt now. The old mindset was you could collect as much data as you wanted, keep it for as long as you wanted, and do more or less what you wanted with it. That's all changed with GDPR. GDPR, we're now looking for a minimalist environment. We minimize the data we have, and we minimize the data the length of time we keep it for. Any tips on establishing an embedded culture of early engagement and privacy by design? Yes, it's find out if the organization has anything like a project office, work with them, see what new projects are coming along. If they don't have a project office, get to know the project managers, find out what they're doing. If you don't have a larger number of project managers, speak to the departmental heads. They're the ones that will essentially authorize any new activities. Find out what they're thinking, find out what they're gearing up to do. You need to get close to the people that are commissioning new activities. So that's where you do it. You can either do it from the project office, if your organization is large enough to have one of those, otherwise get closer to your departmental heads. They're the ones you'll need to talk to. A good question here. Is there a guide to the level of detail held in Article 30 register in relation to the frequency of review required? There's certainly instruction on the amount of detail, considering what fields need to go in there and the type of information, but for actual reviews, no, there isn't. And it's something I would suggest needs to happen at least yearly. The problem a DPO has, and this was referred to it in the first one, the DPO isn't always aware of either things starting or things being decommissioned. So it's very likely you will have entries in your records of processing for processing systems which are no longer running. They've been decommissioned. It's just that nobody told you. So once a year should be adequate to catch those type of things and make sure that your register of processing activities reflects what the organization is doing. Here's a good one. As somebody who knows about risk registers, if I fail to practice security by design, should that be a risk in my risk register? Yes, it should. the GDPR requirements cover a lot of things, and you are basically not meeting one of them. Now, you will not be fined for that by itself, but if you have a data breach and the investigation into that data breach, if it's substantial, and the investigation by the ICO uncovers that you're not meeting the requirements of GDPR, the level of fine against the organization will be increased, and sometimes quite dramatically, simply because you're not following the will and the intention of the legislation. So it should certainly go on your risk register. It carries a risk to the organization of not encompassing these ideals. Now, do we have any more questions? I can't see any more coming in at the moment. I hope you've enjoyed this thing. I'm just going to slip to the last slide here. Because if you have enjoyed this, we are running a series of these webinars on different topics, most of them around GDPR, data protection legislation. But please get in touch with us, and we'll keep you up to date with what we're doing, what our services are. If there's any questions that you think of after this event, please just let me know. We'll distribute the slides and a clear recording to all attendees next week. So thank you very much for attending.